Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. Sir, you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
As the agent for Peyton, Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton, Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton, Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
no, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person, so. And it's
I'm not a person, I am one of the people, thank you.
Okay, thank you.
Every time he gets me. I'm one of the people. I'm the Recovery Addict. Welcome to the Court of Public Opinion. Happy day. Happy day. What day? Well, we have to wait for the music to stop to tell you what day it is, but you guys know what's coming. Oh my goodness. I sorted my screen. I did. I feel like I'm home again after a long trip away. It's good to be back. Welcome. Let's see, let's plug in the burner phone. We have that dying on us today. Oh, I have 18 notifications. Where are you? You said 8:30.
Because he's the guy.
What's 15 minutes between friends? Really. Welcome. It is great to be here. Happy day. Let's see. I don't have any water, so this could be good. This could be bad. Either way, we're going to do it. Here we go.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I'm still here. I'm all right. I survived the hump day yell. My family in the other room did not. So, oh man. Water.
I'm not a camel.
Okay. Let's see. Oh, good morning. It is great to be here this morning. It is really good. I think, fingers crossed, I don't want to say it because that means that it won't be working. I fixed the network issue between my replay machine right back here. Dang it. I knew that if I did something, that would happen. See that screen that's flashing? That's the problem. It worked until I touched it. You guys saw it was working until I touched it.
The apocalypse may be upon us.
Why is it doing this?
Scratch all that. Oh, that was terrible. I apologize.
Let's switch it up to, let's see. Let's see if that fixes something. Clearly it didn't because it's already still flashing.
When are we going to break for lunch, Judge?
Soon.
Have them send
I don't want another one of those. Experience. I mean, I do, but I don't want to. All right, we have to take care of everything that's important because it's time to not do that. That's for starters. Welcome, sample user. This live stream. No, just kidding. Rianne K. Welcome. Congratulations, Rianne. You were first in chat here this morning, the very first.
Don't miss the forest for the trees.
Which was pre 8:30, I might add. But pre 8:30, you were here first in chat. The first person in chat, it sort of breaks the silence. It's quiet. Everyone's just sort of getting geared up for the day, and then you just blurt out "Hi," full volume. I might add full volume. We have determined that act alone is a crime, and it can't go unpunished. So we're going to have to punish you. First of all, we've caught you. Okay, don't think it. Your DNA is all over that text. So we've caught you. We've identified you. You've been arraigned. We've held a grand jury hearing which you don't even need to be there for, honestly. Those things, we learned about those from Karen Reed. Yes, you got railroaded just a little bit, okay? But at the grand jury hearing, we thought we might as well just speed things up and jump straight to sentencing. And that's what I'm going to do now. I'm going to sentence you guilty of breaking the silence and speaking first in chat. I'm going to sentence you to internet ownership for at least until we go live again, probably after lunch. So, Rianne, hopefully that teaches you your lesson. If it doesn't, you can always go and pay your fee, your fine of 50 cents and get a framed copy of the certificate of internet ownership to remind you of your crime and remind you what not to do in the future, which, you can. It's not like there's a graduated punishment that goes along with it. But welcome, congratulations. I think you are a first-time winner, first-time offender, we should say. Great work. Thank you very much.
When are we going to break for lunch, Judge?
All right, we have a couple messages came in. This one, Tisha S. gifted a membership first thing and then said I was about to send out a search party. It was close. You know what I need? I need this. I need it to be bigger. The words are not big enough.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm biggin'. There we go. It's slightly bigger and it's slightly moved. So that's what's good. All right, Tisha S., thank you very much for both gifted membership and for the warning about the search party. I'll make sure I'm not late next time. BGOG, my courthouse changed color. 6 months. Congratulations. Welcome. That flashing is going to drive me nuts. I'm sorry. We've got to unplug this, and that means I have to unplug this and unplug this. Plug this in over here, which I think I have to flip over that way. And now it's fixed. Look. Beautiful. And just when I got the internet working on that, I swear this is my favorite device if it works. If it works, it's my favorite device. But today it's not my favorite device. I cannot get it to work. All right. Courthouse changed color. Thank you, BGOG. Princess Buttercup said, good morning, Ruff. You're such a nerd. I am such a nerd. I see those paw prints. I know you want a custom emoji, Princess Buttercup. I just don't know how to. We don't have enough space. We'd have to get rid of another emoji, and everyone's sort of attached to them. Lynn in South Carolina has been here for longer, but not always a member. I love spending time with y'all. Happy Hump Day. Thank you, Lynn. Appreciate it. Wouldn't be the same without you, but congratulations on the official 7 months. We know it's more. Selena K, so excited to have found this channel. So many great people here. Selena, you are one of them. Thank you very much for the 11 months of support as well. Nicole Wise says, good morning, all addicts. I swear, I will win the internet one day. Thanks for everything, R8. You basically outed yourself. So we know when you do win the internet, you've done it intentionally, and there will be no mercy on the sentencing. It will be a bad internet day, Nicole. Just know that right now. So thank you very much. Okay, we have a couple things to go over. First of all, we have a trial in a little, I think it's a hearing, it may be a trial in Cedric Simpson's court. It's the spicy one. It's the car accident, the one the judge was sort of involved with. He knows the scene. We're keeping our ear to the ground because the way Judge Simpson's courtroom works, it's just like, who's here? All right, who's next? It's not like they follow a strict schedule onto the timeline. So we're gonna have to keep one eye on Cedric's courtroom because that spiciness is going to happen. We saw that already from a previous hearing. We're watching that. Then also, oh, thank you, Mindy FS. Love this channel and community. Y'all are great. Thank you so much, Mindy. Thank you very much. 4 months of support, Mindy. Alley Cat comes in with 7-month message. Love this channel. Thanks for giving us a fun place to hang out. Thank you, Alley Cat, as well. Wow, everyone is hitting their membership mark today. According to Woo, says cheers to cases, car chases, and camels. Thanks for all you do, RA. According to Woo, thank you for all you do. Speaking of all the things I do, one of them is sing happy birthday, and we are going to do that today for Michelle, Libby, Boydston, Lee, and Felicity is home. All have birthdays today. When I say we, I mean all of us, meaning you. And I will join you in singing happy birthday. I will join you in singing happy birthday. Please, everyone, remember your parts. Remember how we practiced. It's important we get this right. You know the words, you know the tune. There's no excuse not to sing. Even if there's coworkers, you might be in a meeting right now. Just belt it out. No one's going to punish you for singing happy birthday during a Zoom call. Here we go. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, Michelle. Let me voice and leave Felicity's home. Happy birthday to you. Dancers, if you hadn't warmed up, I know that snuck up on you really fast, but it's time. You got to be ready to go. Princess Buttercup says you should take a vote to remove one and add my paw prints. Of course you feel that way. Let's see. Did it go on screen? There it goes. We also have Martha Ivy. Love watching with everyone, and RA. Thank you very much. Coffee and Crime. Love my yellow courthouse. 6 months. Hey, this is a great day. Oh no, I missed Gina. Well, the song is still going. Is there anyone else we missed? We're going to try one more. I think. Is there an interlude here? There's an interlude. We'll get the happy birthday to Gina after the interlude. Okay, here we go. Just for Gina. Verse 2. Just crank the music so we're feeling. Dancers, don't stop now. Happy birthday to you. Happy birthday to you. Happy birthday, dear Gina. Happy birthday to you. That felt like an a cappella because the melody dropped out of the music. I felt like I was almost on my own, but luckily I heard voices from the community rising up around me to celebrate with Gina. Thank you very much to everybody who has a birthday today. What a great day. What a great day to celebrate. It's your day. It's your special day. I realize there are a million places you could be and a million people you could be with who would want to recognize you on this, your special day. But here you are, here with us, and that's not lost on me. Thank you so much. I realize you might have to leave early to get your free pancakes at Denny's. That's okay. You'll be excused today only. Make sure you get that done. Free pancakes. We can pass that up. So wonderful, wonderful. Thank you to everyone who has a birthday. We made it to the ending. We rarely do that. Rarely. Good job, everybody. All right, we have one more. TC, says, love RA and RA community from Sydney, Australia, from down under, where they stole our summer and gave us winter instead, and then vice versa. I don't know how they get that backwards, but it's anytime we have bad weather, you have good weather. It's basically you're the opposite. Plus your daylight, nighttime, there couldn't be a more opposite place in the world. I just can't figure out how they walk on the ceiling with the... Yeah, anyway. Okay, that joke was old, but... All right, here we go. Happy birthday. Happy birthday to everyone. Great to be here. All right, we have some things to talk about. We have some things which I'm excited about personally. Okay, Mr. Cedric Simpson is going to be live in just a moment, so we have him right here. Yep, excellent. So we'll keep the audio,
the apocalypse
audio
may be
on
upon
for
us.
him. Let's reset that one and this one. Save that. Now we go over here. We have more. We have a hearing that happened out of California that we want to cover. It's going to take about half an hour. This is the Scott Peterson hearing. Who is Scott Peterson, you say? Well, he's someone who was convicted of killing his wife, Lacey. It's only about a half-hour hearing. It took place yesterday. Why is this even coming up?
Are we going to address subject matter?
Because the LA Innocence Project, for some reason, has determined that this is the case. This is the one that they want to get behind and prove innocence on, which is interesting because it seemed like it was all over the news and it seemed like a slam dunk when it went down. But now they're saying with the new technology we have with DNA, there's a possibility that we can prove this case otherwise. And if so, wow, this guy has sat in jail for quite a while, and now there's a possibility of a new trial. So we have that. Not the Innocence Project, the LA Innocence Project. Different. It's their own little thing. Okay.
What more do you need to see?
Yeah, I'm not sure if this was the best case or just the highest profile one that was available. So we've got to see that. So we're gonna pull that up. I think we'll keep Judge Cedric Simpson on reserve for just a little bit. Let me get my feed running here. We need that on. And we'll hit play down here.
All right, good morning. Good morning, Mr. Peterson. Can you both see and hear the proceedings, sir?
Yes, Your Honor, I can. Thank you.
All right, and do we have your consent to proceed via Zoom this morning?
Absolutely. Thank you, Your Honor.
All right,
He's just
thank
happy
you.
to be here.
So the record should reflect Mr. Peterson has consented to appearing via Zoom. He is appearing electronically from Mule Creek State Prison. Okay, the court had requested counsel to be present this morning for a status conference. There are 3 motions pending before the court. Motion for post-conviction discovery under Penal Code Section 1054.9, a motion for post-conviction DNA testing, and a motion to seal court pleadings that have been filed in relation to those 2 motions. Because we had not yet had a hearing date set, the people's response had not yet been due, so I wanted to discuss with counsel a briefing schedule and scheduling a substantive hearing on those 3 motions. I also wanted to, there were references in the pleadings to potential meet and confer process between the parties to see if they had any luck in narrowing the issues that the court may have to decide in terms of discovery and testing. So I wanted to check in with counsel, see where we are with that process, and then we'll move forward from there. So let me start with the moving party. Counsel for Mr. Peterson.
Yes, Your Honor. We did go to the District Attorney's Office in Stanislaus County on February 13th to have a meet and confer. Unfortunately, we were unable to resolve any issues. I do have a letter memorializing the discussions that were had. If the court would like a copy, I'd be happy to provide that. I sent it to the District Attorney's Office on February 24th, just setting forth the issues we discussed and the impasses that we had.
Okay, thank you. Counsel for the people.
Your Honor, we did have a meet and confer, and we are at the position where we intend to file our motion, our responsive motion. And what we need the court's help with perhaps is identifying the date that we begin to run that time. We have 90 days for service.
Hold on just a second, Ms. Latiger. We're getting a little bit of background. I'm going to mute, or I'm going to ask the clerk to mute Mule Creek because we are getting some background noise. So, Mr. Peterson, if you do need to communicate with your counsel at any point, you can let us know that by simply raising your hand so that we can unmute you. Okay, thank you. Go ahead, Ms. Latiger.
Thank you. So, we received the motion with all the attachments on January 9th. The AG's office, which also needed to be served, received the motion with the attachments, exhibits, on January 23rd. So we will be ready to file our response by 90 days from either of those dates. We're looking at either April 22nd from when the AG was served or April 18th from when we were served.
Okay. And so if that's going to be when you're going to be filing your responses or when you're going to be ready to file your responses, how much time would Mr. Peterson's counsel need to then file any replies?
Your Honor, we would ask for 2 weeks.
Okay.
Can I just inquire, we were given somewhat mixed signals at the meet and confer concerning whether the District Attorney's Office intends to file a blanket opposition to both motions or whether there are some specific items that they will be objecting to and others that they will not with respect to the discovery motion. So if the court could inquire whether they intend to file a blanket motion opposing all requests or if it's with respect to certain items, perhaps we could begin receiving the items that they are not objecting to.
I mean, I would expect that the counsel could handle that in the meet and confer process. So the people are entitled to an opportunity to respond. They can decide what the scope of their response is going to be. If you're going to need 2 weeks to respond to that, then I will set a hearing that contemplates that you will have time to file a reply and I will have time to read all of the pleadings before we have the hearing. So let's see. If the people are looking at being ready to file their responsive pleadings by the 22nd of April, and counsel's going to need at least 2 weeks for the reply, then that would put us with a briefing finishing somewhere around May 6th. So we would be looking at a hearing. I'd like at least 2 weeks to review the last of the pleadings, so somewhere on or after the 20th of May.
Your Honor, if I might,
yes.
In terms of the timing of our response, I was speaking specifically about the DNA motion.
Mm-hmm.
That we'll be ready to respond to that on that date.
Okay.
And then we would ask for an opportunity to file a response to the discovery motion as well, and we would ask 90 days from the date we file the DNA motion to respond to the discovery motion.
Is there a reason that you need an additional 90 days beyond for the discovery motion, or why they can't go in parallel, Ms. Latiger? Yes, or Mr. Harris?
Yes. As the court may have already seen in the pleadings, the defense pleadings in this particular case, specifically for the DNA motion, is 142 pages of pleadings, plus over 880 pages of exhibits that are attached. The exhibits came to us later than the initial pleadings, and so that's been one of the delays for us, having to go through each of those particular exhibits. The statute for the DNA motion does have a 90-day deadline. The statute for the discovery does not have a deadline. It's been interpreted by the court to be a reasonable time frame. We think that the DNA motion would also assist, having that resolved would also assist in some aspects as to the discovery motion, because specifically in the statute it says that the two do not work necessarily in conjunction.
Right.
Also, the discovery motion itself is another 62 pages with a large volume of exhibits for that as well. So we've been concentrating on trying to get the DNA motion, which does have the deadline, done. A lot of the materials that we will have in the DNA response will be applicable to the discovery, but we just think a reasonable time period based on the size of these motions, it's not unreasonable to ask for another period of time.
Well, I guess the concern that I have about 90 plus 90 in terms of your responsive pleadings is that the Court of Appeal has issued a stay for a relatively limited period of time. We're working on a 6-month deadline before, and I understand that there is the potential for an extension of that deadline if there's additional good cause, and not being done with the pleadings here and with the hearings here determining the scope of the discovery would potentially be good cause. But given that they have sort of given us a 6-month time window to work with for what they think would be an initial opening, I'm concerned that setting a briefing schedule for that exhausts the entirety of that time period is not going to be viewed as potentially reasonable by them. So, and these two statutes, while I understand that a lot of the issues may be interconnected with the discovery the defense is seeking, I don't see a lot of what they're seeking in the 1054.9 motion appears to me to be in the nature of file reconstruction. Some of it, not so much, but there are things where essentially they're asking for missing bait stamp numbers and other things that are referenced in reports that they already have. I don't understand why that couldn't be worked on in parallel. That's what I'm still waiting to hear. So if the people want to address that, I'd be happy to hear any argument on it.
Yes, Your Honor. One of the things as it relates to the discovery motion, there was a couple of issues. One is we believe it to be issue preclusion. For in fact, there has already been a previous 1054.9 motion that has been brought, has been litigated, and resolved primarily against the defense back in 2011, 2012. So because of that, we have to go back and we have to call out what has previously been dealt with, and that's requiring us, again, to go back through things that are not necessarily in their materials, but it's in the court record. We also believe that a lot of these items have been raised and litigated as part of the initial appeal and also litigated as part of the first habeas. So because of that, and unfortunately we will be providing to the court or asking the court to take judicial notice of the petition that was there because a lot of these issues have been raised and have been adjudicated. So because of that, there's a lot of back and forth from the record, and there is going to be a large amount of reading for both sides.
Okay. That brings up another point. The defense did make a request in the initial round of pleadings for the court to take judicial notice of the entirety of the trial court file, the entirety of the direct appeal, the entirety of the habeas proceedings, and all of the Supreme Court proceedings, including all the pleadings. Is there any objection to that request from the people?
There is as to some portions. We have a portion of it in our response to the DNA motion to address that. But okay. Basically for the court, anything that is part of the record of the case that has been adjudicated, we have no objections to that being taken judicial notice of because it's the law of the case in a sense. What we do have a complaint about is there's a request from the petitioners that the court take judicial notice of their pleadings in these new proceedings. Those are hearsay, and just because they've been filed does not make them admissible. So because of that, we will be objecting to those portions of their request, but the fact that there is a new petition, and the previous court proceedings, those we don't have any objection to for judicial notice.
Okay. The reason I inquired was because since you had referenced that there were other parts of the file that you were going to be asking the court to take judicial notice of, I thought we might be able to get at least some of that out of the way. But if it's going to be covered in your responsive pleadings, I will wait to rule on any request for judicial notice until I see what the scope of the dispute is. All right. So let me hear from the defense on the proposed briefing timing and timing of potential new hearings.
Yes, Your Honor. We provided a very, very detailed informal request for discovery on November 14th, 4 months ago. So the District Attorney's Office has known for 4 months which specific items of discovery we are requesting. We gave them references to Bates pages. We gave them references to where in the police reports the items we're requesting are referred to. We were very, very specific. We spent a lot of time trying to suss out what frankly are very alarming deficiencies in the discovery that was provided to the defense at the time of trial. Those are the items we're requesting. I agree it should not take 180 days for them to locate those items and provide them to us. The defense was entitled to those at the time of trial. Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided. So I don't think that the nature of the requests, it's not a fishing expedition. They're very precise, they're very specific, and we believe that they are probably very easily accessible. So we would ask that they begin providing the discovery that we are entitled to under 1054.9. The prior 1054.9 that Mr. Harris referenced does not include what we are asking for. It related specifically, almost exclusively, to expert materials and other evidence that is not included in our motion. So we are eager to get our investigation underway and completed. The Court of Appeal did give us a very short time period within which to conduct our investigation. The materials we are asking for are reasonable. They're within the scope of 1054.9, and we would like to begin receiving that discovery as soon as possible.
Okay. So in terms of briefing schedule, the court is prepared to accept the proposal by the district attorney as far as the DNA testing motion is going. And so the response for the responsive pleadings on the DNA motion will be due no later than close of business, filed and served by April 22nd. Given the timetable that was contemplated by the Court of Appeal and the fact that essentially the discovery request was made prior to this motion being filed and prior to the Court of Appeal issuing their stay on the proceedings to allow these issues to be litigated in the trial court, I am inclined to agree with the defense that a request for an additional 90 days beyond the briefing on the 1054 issues is too long, given the timetable that the Court of Appeal has given us. In terms of the briefing for the 1054.9, because the requests are extensive, it's a 62-page discovery letter with a number of subparts. Some of it is specifically identified by missing Bates stamp numbers, but some of it is broader than that. So the court is inclined to go about 30 days beyond the briefing deadline on the DNA motion. And so if I'm looking at roughly the end of May for the 1054.9 reply, could you have it done on or before the 20th of May?
Yes, Your Honor.
Okay. So May 20th will be the briefing deadline for the 1054.9. All right, and then with the, so if you're looking for at least 2 weeks for the reply, Ms. Mitchell, that your reply will be already done on the DNA before you get the responsive pleadings on the 1054.9. How much time do you contemplate you'll need for a reply on the 1054.9?
We could file our reply by June 3rd.
Okay, so reply pleadings for the defense on the DNA will be due, if you're looking for 2 weeks, that would put it May 6th. And reply pleadings for the 1054.9, you indicated June 3rd, so that's fine.
So it's June 6th, the next
Motion
date?
to seal. That is something that I think we probably can and should do before we deal with the substantive pleadings. And so I did not see a responsive pleading on the motion to seal. How much time do the people think that they would need on a responsive pleading to the motion to seal?
The only issue that we have as to the motion to seal, and this is why we have not filed something, is the documents in question that are being requested. The people have never been provided with an unredacted copy of those reports. We still do not know who these witnesses are. They're anonymous to us. So we're asking the court to order the petitioner to turn those over to us before we can actually decide one way or the other. But the people's position is we probably won't be objecting to the motion to seal based on what's alleged once we have that information.
Okay. Ms. Mitchell?
Your Honor, the identity of the witnesses whose names are redacted in the declarations that Mr. Harris is referring to have stated that they are fearful of retaliation by the Modesto Police Department if their names become known, and have asked that their names remain sealed. I would request that we perhaps have a conference in chambers to discuss this issue. It's sensitive to our ongoing investigation. There are a number of other witnesses who we have been investigating who are in a similar situation.
Okay. Well, all I'm asking for essentially is a briefing schedule for the motion to seal. And there's a procedure that's set forth in the rules of court for a motion to seal in terms of lodging a pleading with the court that is the proposed sealing and the narrowly tailored nature of it, and serving it on the opposing party. It appears that that actually hasn't been done in this case. All of the pleadings that were filed were essentially filed publicly, but with the redactions that you are proposing. So in terms of the procedure for the motion to seal, it is, I would say, somewhat unusual given the rules of court. And I anticipate that the parties will not be the only ones who want to be heard on the issue of the motion to seal, given the nature of the case. So let's set a briefing schedule. I'm not going to make any specific orders, and whether or not the motion is compliant with the rules of court and the proposed redactions are within the nature of the rules of court is something I'm going to rule on at the time of the motion, not now when I have one motion, not a response, and not all the pleadings that I anticipate that I'm going to get on it. So how much time would the people need in order to be prepared to file a response to what is in the record?
2 weeks would be fine.
Okay, that's fine. And then any reply that you may have to that, Ms. Mitchell, how much time would you need once you get the people's response?
1 week, please, Your Honor.
Okay, so 2 weeks from today is the 26th of March, so people's response will be due March 26th, close of business. And you said 1 week, Ms. Mitchell, for your reply. That would put it about April 3rd. So April 3rd for motion to seal reply.
Deadlines for the responses and the response to the response.
And we will need to set, let's set a hearing date on the motion to seal, and then hearing dates on the DNA and the 1054.9. The hearing date on the motion to seal can be earlier, so that'll be, we'll do that first. Proposals from counsel if we're looking at April 3rd for the close of briefing, and the court is going to take, the court will need about a week to review on the motion to seal. So anytime after April 15th is fine. What's counsel's preference?
That's going to be the next hearing that we have in this one.
We can do April 16th.
April 16th is fine for us.
Okay, April 16th is the next date.
Let me just check the court schedule.
As long as the court agrees.
Yeah, I'm free April 16th, so that's fine. April 16th, 9 a.m. motion to seal. And Ms. Mitchell, is Mr. Peterson going to want to be personally present for that or continue to appear electronically?
My understanding is that his preference is to appear electronically, but he can correct me if that is not accurate.
Okay, and can we, let's go ahead and ask to unmute for that.
That's fine by me. You have to push the mute button again.
Still muted.
He's happy about it. He's like, look, I'm just happy to be here. None of these buttons work, Mr. Peterson.
All right, Mr. Peterson, we're contemplating an April 16th hearing on the motion to seal the pleadings or parts of the pleadings in this matter. Are you going to want to appear via Zoom or in person for that?
Zoom is fine, thank you, Your Honor.
Okay, thank you. Then, for hearing dates on the DNA motion and the 1054.9, what's the party's preference in terms of hearing those together or separately?
Your Honor, we would prefer to have the DNA issue resolved as soon as possible so that if there is going to be testing ordered, we can get that started.
Okay, people. Okay, that's fine. So if the briefing on the DNA motion is going to be completed by May 6th, then, and if I need a couple of weeks to read the pleadings, then we're looking at the last week of May. So any preference by counsel during the week of May 27th for the hearing on the DNA motion, and what is the time estimated necessary for that argument?
We can be available May 28th, Tuesday, May 28th.
Okay.
That is the day after Memorial Day, so I don't know if that's going to cause travel problems or any issues for the court's calendar.
I don't have any plans on Memorial Day, but if counsel do and they would prefer to go to the 29th or sometime later in the week, that's fine.
29th is fine.
Okay. And do we think it'll be anything more than a full day?
Full day. Wow.
I don't think it should be more than a full day.
Ms. Mitchell?
It's more than Karen Reed got.
Having not seen their opposition, I can't say, but I would hope not more than a day.
Okay, we'll block off a full day for it, so, and it may not take that long, but we'll be prepared if it does. May 29th at 9 a.m. for the DNA testing motion. Then the 1050, and so in terms of the DNA testing motion, Ms. Mitchell, do you know if Mr. Peterson has a preference in terms of Zoom or personal appearance?
I believe his preference is Zoom.
Is that correct, Mr. Peterson?
Yes, Your Honor.
Okay, so that'll be via Zoom. Okay, and then we'll need to schedule the 1054.9 hearing. If the briefing is going to close on that on June 3rd, then we will need, if the court needs, that is going to run into some travel plans that I have, and I'm going to need to step off the bench briefly to confirm exactly when I'm returning because it's an extensive absence in June. So let me step off the bench briefly, consult my calendar, and let you know after essentially when I'm going to be returning and when I will be available for that, and then we'll discuss dates. So we'll take a brief recess.
Okay. I'm fine with not knowing this date. If anyone knows it, we're going to go ahead and cut from here and go ahead and jump to another hearing. So basically, what we have while this is going on, let me just recap. Scott Peterson, accused of killing his wife Lacey Peterson 20 some odd years ago. This all went down. It's been 21 years. The LA Innocence Project, which sounds similar but is a different entity from the Innocence Project, which we're familiar with, has taken on his case and said, we've looked at the facts, we believe that with new technology, with new testing, specifically DNA testing of existing evidence that may be out there, we think that we can prove that her blood would be present on a mattress that was found in a vehicle involved in a robbery across the street or something like that. Okay? Bit of a stretch, possibly, but if true, this would be significant because her blood should not be there at all. It's a situation where she is unrelated completely with that case currently as we know it. And so if that's true, that would mean that it was burned. It was burned. Okay, nice. Nosy Rosie, it's an uphill battle, I'm telling you. It's an uphill battle. But if that's proven true, that would be very difficult to fit into the narrative that the police have, because that robbery across the street and everything, that was not involved at all. And now, then you're saying, okay, she was abducted, and it just all that crazy evidence that we had that was presented against Scott Peterson, which was all circumstantial, suddenly it no longer fits the story. So that is what they're trying to do. There's first going to be a hearing. So let's see, April 14th. Excuse me, April 16th. They're going to do a motion to seal the hearing. 2 of the witnesses appear to be police officers who fear retaliation if they testify. At least that's what we're hearing here. At least what's been presented to the court, which we believe is true. So those 2, they want to seal this motion so that the names don't come out, so that it probably will be sealed from the public to some degree on that front. But that's going to happen. A decision on whether or not to seal is on April 16th, and there's some other motions until
In terms
May 29th.
of the court's availability for the 1054.9 motion, I'm going to have to go until after July 1st.
Wow, she's taking a month
So,
off.
counsel, I'm looking at sometime during, if I'm going to be reading the pleadings after I return, I'm going to be looking at sometime during the week of July 15th.
We can be available July 15th, Your Honor.
July 15th?
Okay, July 15th, 9 o'clock, and in terms of your client's appearance preference, Ms. Mitchell, also Zoom or in person for that one?
Zoom.
Okay.
Zoom.
Mr. Peterson, is that correct? Still muted.
Poor guy. This may be his first encounter with Zoom, like literally. Technology is hard. The facial expressions are great, though.
All right.
Yes, Your Honor.
Okay.
Zoom did not exist when
last housekeeping matter, the court did
he was
to
locked
the court's department email receive an ex parte communication from apparently some kind of a spectator. I read about one sentence of it, enough to realize it was an ex parte communication, did not read any further, and counsel have been provided, as I understand from the clerk, copies of that email. Did both counsel receive it?
Yes.
Okay, thank you.
Somebody sent a letter to the
And
judge.
the court is not going to be reviewing any incoming email to that inbox in the future to avoid that issue recurring in the future. So people shouldn't bother to email. Okay, is there anything else either counsel needs to take up for today's date before we recess?
Don't email the court.
Yes,
I received a number of inquiries from members of the press and the media asking for copies of the motions we filed. We have not provided anything to anyone in the media or the press. Apparently they are not on the court's website, and so I'm just asking for guidance. Is there any issue with us providing the motions, or is the court planning to put them on the website so they are available?
I don't have any plans in that regard while the motion to seal is pending, at least, and I have not made any orders about what counsel may or may not do in terms of their communication with the media.
Thank you, Your Honor.
Okay.
Your Honor,
Yes.
if people can make a suggestion. One of the things that Judge DeLuca did during the trial, because of the media attention and not wanting to be distracted by additional requests that would come in from the media once a motion was filed, his position was that he would take the motions filed by either side and he would hold them from being put on the website or from public filing until the other side responded.
Mr. Pruitt,
Because
can you hear
a lot of
us?
times that resolves some of the issues or questions that may have
Okay,
arisen.
state your name, please.
So we would suggest that might be a possibility here as well.
The difficulty, and I think part of this, Mr. Harris, is that the court's filing procedures have changed since Judge DeLuca was the file. We don't have a lot of control over when things come in now because it's all electronic filing. So I don't actually see it until the clerk's office processes it. So while I appreciate the suggestion, it's not consistent with our mandatory filing procedure. So thank you all.
Thank you, but no thank you. All right. So that is the end of the hearing for Scott Peterson. There was another hearing that went down yesterday as well, related to the Alec Baldwin case. But I see Judge Cedric, he burst in like sort of on surprise with us. He burst in. He looks like he's begun his court date. If I could have somebody who has the ability and the interest to sort of keep an eye on Judge Cedric, we want to see when that court case comes up. He has a full docket, but let's see. I just want to see when it does come up.
On behalf of Mr. Getz, Your Honor, this is a date and time set for sentencing. We have reviewed the pre-sentence investigation report.
This is not it. That's not it. But if we can keep an eye on Judge Cedric, what we're watching for, the specific case, and if somebody's able to find some schedule of some sort, that would be even better. With Cedric Simpson, we're looking for the John Torres case. John Torres, which is slated for 9 a.m., but all his cases are slated for 9 a.m. That's the way he runs his docket. It could happen later in the afternoon, but Kool-Aid Man burst in. Yes, he did. All right. So we have the latest on Scott Peterson. Obviously, most of us, I would say most of us have heard of that case. That was huge. It was, the news coverage was just, it was pervasive when it happened. It was everywhere, and yeah, it was crazy. So now being in this situation, a lot of us just can't believe it. It seemed like an open and shut case. Looking back, there was a lot of circumstantial evidence, which I think will be difficult to overcome, because even though it's circumstantial, there was a lot of it, and it sure made him look bad. Greta K gifted a membership. Thank you very much. Thank you very much. We've got about a half hour hearing in the Alec Baldwin case that we can go over. This is related to the civil suit, and then we're going to try. Well, we can pause this at any time, because we can jump over to Judge Cedric Simpson, because we have this case with John Torres, which we really want to hear the outcome. This was the one for Cedric Simpson, was the car crash, I believe, where there was like pursuit and the girls lost control, and I think they died. I think it was fatal. So it was, yeah. Anyway, it was crazy, bizarre, circumstantial evidence. Yes, a lot. Passports, cash, change of appearance, girlfriend on the side. There was a lot of circumstantial evidence. Okay, so now we're gonna jump. We're gonna clear this thumbnail or clear this this pinned message, because we're now going to jump over to the hearing that happened in. Let's see. This is going to be camera 7. Audio follows video. There we go. Where's my mouse? Okay, here we go. Wait for it. Okay. Camera 7, cut.
Plaintiffs.
That's through a Google meeting.
Good afternoon, Your Honor. This is Robert Schwartz on behalf of defendants Alec Baldwin and El Dorado.
Good afternoon, Your Honor. This is Nick Govea on behalf of Rust Movie Productions, LLC.
Everybody's here. All the players. Please announce.
All right. We're here this afternoon on defendant Baldwin and El Dorado Picture Inc.'s renewed motion to stay these proceedings, or stay discovery this proceeding, pending the resolution of the criminal proceedings. So with that,
which means
Mr. Schwartz.
Thank you, Your Honor. Your Honor, I'm very mindful that this is our second appearance before the court requesting this relief. And the big difference between the last time we saw you, which I believe was at the end of August, and today, is that the grand jury has delivered a criminal indictment of 2 manslaughter charges against Mr. Baldwin. And he is facing a very real threat that he was not facing at the time we saw you before of the criminal proceeding. And in that interim, 2 judges in 3 other civil cases, the civil cases in California, arising from the same incident, those 2 judges in those 3 other civil cases applied the same facts to the same legal principles and decided that it was appropriate to stay the discovery or against Mr. Baldwin and his personal services company, El Dorado, pending completion of the criminal trial.
And so should I ask, was it pending completion of the trial, or was it pending completion of the proceedings? I say that because with appeals and other things that can happen, that's a pretty significant distinction.
Right, and we're talking about the trial today. That's all we're asking for.
Thank you so
those
much
judges
for your
were phrased it in terms of criminal proceedings, but Your Honor, what we didn't have when we were in front of those 2 judges, but we do have today, is we know that in 4.5 months, the criminal trial will most likely be done. It's scheduled to start on July 10th. In this case, similar to the other cases in California, there's no discovery completion date. No discovery completion date has been set. There's no trial date in this case. And I think we can all have some assurance that discovery in this case will still be going on in September and October of this year, and even beyond that, most likely, after the criminal trial has been completed. What's going on here, and it's very clear from page 8 of plaintiff's opposition, that what this is about is attempting to force Mr. Baldwin to show up for a deposition during a period of time when he really could be working with us to prepare for his criminal trial, and repeatedly assert his Fifth Amendment right. And they made that very clear on page 8 of their opposition. They want to create a record from which a jury could draw negative inferences against Mr. Baldwin by his assertion of his constitutional rights. Now, that's not a proper inference to be drawn, and it's not a proper reason to refuse a stay of discovery. And if the court is not going to allow the plaintiffs to have the jury draw those inferences at trial, then what's the point? There really isn't any of allowing the plaintiffs to create that malignant record over the next few months. And so while Mr. Baldwin is fighting for his freedom, here we are fighting over his money. The better course is to do like those other judges did and stay discovery against Mr. Baldwin, at least until the criminal trial has completed sometime in July. Thank you.
All right. And then there's the issue of the Eldorado pictures, right?
Eldorado, yes, it's there. That is a company that exists solely to furnish Mr. Baldwin's services on this movie. He is the sole owner, he is the sole officer, the sole director. It is predominantly for business and tax purposes, but there's nobody else who can testify on behalf of Eldorado other than Mr. Baldwin. And that was recognized very clearly by Judge Ricana and forgetting the name of the other judge, that the stay, as a practical matter, the stay needs to be as to both of those related defendants.
All right. Thank you. Who's arguing for plaintiffs?
I am, Judge. Pick V. Hill.
All right. Whenever you're ready, counsel.
Thank you, Judge. Your Honor, I think that defendants' pleadings make it clear that they intend to assert their Fifth Amendment rights under most, if not all, circumstances. The court mentioned the idea of the fact that the proceedings would not necessarily be concluded just because there's a trial date or even a trial. There are appeal stages that go on for years and years. We're all aware of those, of the Court of Appeals, the Supreme Court.
I can explain this. Hang on.
And there will arguably be an argument by defense counsel that Mr. Baldwin is at risk well into the future, no matter what, pending appeals, pending decisions, potentially by prosecutors to bring other charges. I too was a little confused by what it was defendants were requesting, because in their motion for renewed stay, they requested a stay of discovery against them pending resolution of the criminal matter. Now, that criminal matter is, as I just said, something that could just go on ad infinitum. In their reply, they asked for a stay of the action. So I was a little unsure about what it was exactly they were requesting, but in either situation, Judge, Mr. Baldwin could go on for years and years claiming his Fifth Amendment privilege. Now, New Mexico permits a negative inference to be drawn by the exercise of the Fifth. That's codified in Rule 11.513, comment upon or inference from claim of privilege. So the law is what it is. This court has ruled previously on pretty much an identical motion. The court considered all of the factors put forth by defense counsel during the last hearing in August of last year. And
He's
the only
facing
thing that
both
has changed
civil and
is
criminal.
it is true that Mr. Baldwin has been indicted and there is a trial date set. But as these criminal matters go, it will always likely be an exercise of Fifth Amendment privilege by Mr. Baldwin. So plaintiffs would ask the court, having considered all of the factors in the past hearing, to allow this matter to proceed. In addition, plaintiffs would ask the court to set a scheduling conference in order to set deadlines so that we can get the ball moving on requesting availability by defense counsel and their witnesses for various depositions. I think without some sort of a court order in place and deadlines in place, plaintiffs are going to find it impossible to gain availability for depositions and further discovery of the like. As it was,
Mr. Beal, did you ask for a scheduling conference? I didn't see that in the.
I did, Your Honor. I sent that in several weeks ago.
Okay, on the 26th of January. Did you submit a proposed text?
I'm sorry?
Did you submit that? Sorry, just one moment.
Judge hangs up on everybody. I'm sorry, we're having. Okay, so what we have here, Alec Baldwin is facing a civil suit and a criminal suit related to the death of Helena Hutchins on the Rust set.
All right, apologize for that. I was getting so much feedback there for a moment. I couldn't clearly hear. So, Mr. Beal.
Yes, Your Honor.
I see you requested. Did you submit that to my proposed text?
I believe that's where we sent it, Your Honor, and I can resend it as well.
That would be helpful. I don't recall seeing that. I did not see that in preparation for this hearing. And that is certainly how people get before me to get those deadlines and scheduling orders that you're requesting. So fair enough on that. And let me ask another issue, because at the last hearing, I think the bulk of our exchange was, and this is true with all counsel, was about the fact that some discovery could go forward, but that I did understand that there could be questions posed to the defendants that would quite predictably elicit a Fifth Amendment indication, and that I wasn't inclined to think that that would necessarily be appropriate. So I was trying to make sure that discovery happened in a way that it could move forward where productive, and not have everything stayed, but not be unfairly prejudicial to the defendant. So where has discovery gone from your perspective? By that I mean the perspective of the plaintiffs.
Yes, Your Honor. So I was trying to be quite cautious given the court's comments during the last hearing regarding scheduling Mr. Baldwin's deposition. So I did not do that. I didn't request it, didn't do it. And I further refrained from submitting any interrogatories to him personally. So what we, the plaintiffs, did was we submitted a round of discovery to the third defendant in the case, aside from Rust and Mr. Baldwin. We submitted a round of discovery to El Dorado Pictures and interrogatories, requests for production. Absolutely nothing productive came from that other than a litany of rote and template objections to every single thing we asked. And so I think that is a forecast into what we're likely to see in this case. The court has indicated they have other tools for protecting, like protective orders and other curative mechanisms. And I think those are of course, still available to the court as it sees necessary. But without the scheduling order and without the ability to proceed against Mr. Baldwin and the third defendant, El Dorado, we're just going to be at a standstill. We've gotten some decent discovery from Rust, the other defendant, but there's a lot still to be done. And where defense counsel has now placed the plaintiffs in a position of having to send multiple good faith letters prior to filing our motions to compel. And so that's what is now in the offing. And I think it's only going to get worse with a stay and without a scheduling order that allows us to have deadlines that are forced upon all parties in order to meet discovery needs, such as the multiple depositions that are going to be required.
All right. And am I correct? I saw preparing for this hearing today that the plaintiffs have had discovery propounded to them and that they've answered that discovery?
That's correct, Judge. All three plaintiffs received a fairly large packet of interrogatories and have answered all of those and served them on defendants.
All right.
May I, Your Honor?
Yes, I would. Was about to ask you to. So yes, whenever you're ready.
So, first of all, we didn't put the plaintiffs in this position. Okay, the New Mexico criminal prosecution put this case and these parties in this position, and we are trying to manage it as reasonably as possible. And so when we hear from the plaintiff about how we served objections to their discovery, what happened is when we got their discovery, we said, would you give us an extension of time to respond until the court rules on the pending motion to stay? It's a common courtesy. They refused. And so they left us no choice but to preserve Mr. Baldwin's rights by objecting to the discovery where it was objectionable. We have not served any interrogatories on the plaintiff. Our motion for this stay has not prevented the plaintiff from taking discovery from Rust Productions, the company that made the movie, that hired the people. It has not prevented them from taking third-party discovery if they wanted to, these depositions they allude to. We haven't stood in the way of that. And if that discovery needs to be taken in this case, there's nothing that we've done that would have prevented them from doing it. They haven't done it, and they have their own reasons for it, but that's not on us. The real question here is what protection? I mean, the court alluded the last time to some protections it could give Mr. Baldwin if the plaintiffs depose him in the next 4.5 months, which, as I've explained, is not a time deadline that that anything in this case imposes on the plaintiffs. What protection is there? And the court, we talked about it, but the court didn't say what it was. And if the court has in mind...
My recollection is that we discussed protective orders and motions for protection. We discussed if there were answers that were thought to be unacceptable, motions to compel. I think we brought all that up. As I recall.
Your Honor, what would the protective order say? I mean, a protective order is an order, but what is the protection the court would be providing under the protective order? That we didn't discuss. And the court...
So, Mr. Schwartz, I'm not here to be drawn into an argument with you as much as to tell you that my orders are often highly dependent upon the factual circumstances and legal arguments brought to me. So I'm not going to tell you what exactly an order would say that has not been requested. But I can tell you that it is a mechanism by which this court can control discovery and provide protections if necessary.
Well, that's what we're asking for now. It is a form of protection.
You're asking for one particular type of protection. And I will say you've clarified helpfully, because I agree that your motion that asked for a stay of discovery against them pending resolution of the criminal matter, which can mean a lot of things, was not helpfully specific. So it's helpful that you're telling me now you're looking for a stay as to these two defendants through the end of the trial.
I am, Your Honor. I mean, and I apologize for creating that confusion. I see what you're talking about. I agree with the court. Poor choice of words on my part, and I apologize for that. In that regard, I think, I mean, look, we don't know what's going to happen in this trial. And depending on the outcome of this trial, the Fifth Amendment issue could be mooted. I don't think the district attorney or the special prosecutor has said anything about filing other charges. I think that would create some serious double jeopardy issues depending on what happens. But none of us is in any position today to know what that means or what that could hold. But it is, as long as counsel brings that up, no protective order from this court could prevent or protect Mr. Baldwin from the use of any testimony or deposition he would give in this case from being shown to a grand jury. That's a case we cited. That's the In re grand jury case.
That's why he's
we cited in our motion on page 13. So that's the only reason why I inquired what protection. I mean, if the court is, if a remedy the court would consider is to say that no, the plaintiff cannot allow the jury to infer anything from Mr. Baldwin's assertion of his right against self-incrimination, that could change the character of this motion. I accept the court's position that it can't rule in the abstract or here today how it would rule, but the simplest and most effective solution to this problem, given that there is no deadline in discovery, given that this criminal trial will be over in 4.5 months, is to say to these two defendants, plaintiffs, take the other discovery you need, and if the criminal trial is the end of that criminal proceeding, depose Mr. Baldwin. That's seems to me to be, and that's what most courts have said, and it's what the judges in the 3 other cases have done. So I urge the court to take that simple approach and not allow the plaintiffs to create a record from which, in our view, they can prejudice Mr. Baldwin's rights at trial without knowing anything more about what the court might be able to do to prevent that from happening. So that's our position, Your Honor, and I thank you very much.
All right, thank you. I'm going to go off camera and mute for just a moment while I look through my sticky notes that I put on your bound copy so I don't bang into the microphone. But I will be right back on with either follow-up questions if I neglected to ask something or a rule. Just a moment.
Okay, so Alec Baldwin is charged civilly and criminally, and this hearing is regarding the civil case. The civil case, the people who are suing him, they're suing him for money. If he loses a civil case, all it is money, right? It doesn't put him in jail. They're suing him. They're saying, we want to go ahead. We want to depose him. We want to ask him questions. We want to sit him down and make him answer the hard questions. But we know that when we do that, he's going to say, I plead the fifth, because anything he says here can be used against him in his criminal proceeding. Why would he give them anything that could make it easier for them to convict him criminally? Okay. Now in New Mexico, the law allows the jury in the civil proceeding to make a negative inference about pleading the fifth. That means if you say I plead the fifth, it can be held against you. Okay, not that it's wrong. You're not allowed to plead the fifth, but they say because you're pleading the fifth, we can assume that there's something out there you don't want to tell us. Okay, and so he's caught between a rock and a hard place. If they move forward, then it's a default I win button in the civil suit. If they if he that's if he pleads the fifth. If he doesn't plead the fifth, then he stands a much higher chance, if there is such a thing, of him being convicted in the criminal case. so it's that's where we're at. The judge is going to make a decision. I think he's going to put a stay on this. He's going to say, look, you can't do this. That puts him in between a rock and a hard place, and you've got to stop. And that's fairly common. It's a loophole in the Fifth Amendment in New Mexico. So that's where the judge is going to decide. The criminal should always go first. I agree. The criminal should go first because it basically makes him, if the civil case is allowed to go forward, it doesn't allow him to present any sort of defense without fear of jeopardizing his own.
Thank you very much for your patience.
Freedom.
I believe I have answers to my questions. So my ruling is as follows, which is the motion is partially granted in that there'll be no depositions of Mr. Baldwin individually or 30B6 depositions related to Eldorado Pictures, Inc. between now and the conclusion of the criminal trial in this matter. Following that trial, we can determine how discovery moves forward if needed in those areas. I'm not staying written to discovery. Parties have a continuing duty under New Mexico law to confer in good faith and work to see if they can confer and come up with discovery, scope of discovery that moves the case forward and is appropriate under the circumstances, and I'll expect counsel to do that. If there is a failure to answer that is objectionable, there's motions to compel. If there is the feeling that there's a need for protective order or confidentiality order or anything else from the defense, or I would say, I guess, responding parties, it could be at some point the plaintiffs, you can bring that to this court. But I think that's adequate protection going forward to protect Fifth Amendment rights and ensure that this trial or this litigation proceeds apace where it can. And I should also say, as it's been brought up a few times, nothing about this ruling is meant to be a criticism, veiled or otherwise, of any other judges in any other jurisdictions looking at this matter. I'm applying New Mexico broad discovery standards and looking to make sure that the trial's conducted or the litigation's conducted appropriately under our law. So I wouldn't want to cause anyone offense on that front. Is there any ambiguity that I've left, Mr. Schwartz, as the person I'm going to ask to draft the order, because I'm partially granting your motion?
Thank you. I was going to ask if you would be issuing an order, so you've answered that question. Yes. When you say written discovery, I assume you mentioned interrogatories. Are you talking also about
requests for production and interrogatories?
Got it. Thank you. All right. Then no, I will prepare a proposed order and circulate it with plaintiff's counsel, and we'll submit it to the court.
All right. And any questions, Mr. Beal?
Yes, Your Honor. Just one point of clarification. So your ruling relates to, as Mr. Schwartz has indicated, conclusion of the criminal trial scheduled for July 10th of 2024 in Santa Fe County. As I understand it, I just wanted to make sure that was the court's ruling.
That is the court's ruling. I will say, noting that sometimes we do a good job managing cases in this district, but sometimes delays happen. So if that trial is bumped back, I don't want the order to be drafted in such a way that we have to revisit it every time. But it is that trial that is currently scheduled in July, as I understand it, that I'm referring to. And it's the conclusion of that trial that would trigger the ability to request a deposition. And again, Mr. Schwartz, be aware that depending on the state of the proceedings at that time, you can file motions for protective order and things like that at that point. So it's not as if all remedies are no longer available to you, but that's when we can move forward with depositions.
Understood, Your Honor. All right. I'll work with counsel for the plaintiff to submit an order to the court.
All right. And Mr. Beal, I shifted on you there to someone else. Did you have any other questions?
No, Judge. It would only be contingent on other possible outcomes of the Baldwin criminal trial in July. For example, a hung jury or plea bargain, that kind of thing. But
well, I will be here. I don't intend to go anywhere. So if there are other developments or it goes in a direction that we can't possibly know at the moment, file a motion and get it before me, and we'll get it considered promptly. I think this matter was expedited, so you all know that if there are issues of some urgency, we can get them set pretty promptly. And again, to your request for scheduling conferences duly noted, and we'll get that set in the near future.
Thank you, Judge.
Thank you, Your Honor.
All right. Thank you all very much. With that, we're adjourned and you're dismissed. Have a good rest of the afternoon.
Thank you.
All right. So that's how the Baldwin conference in the civil case went, which is always exciting. So they do get the stay that they wanted, meaning that the civil case will not move forward until after the criminal case is completed. And that was honestly, that's the right decision. There's just no other way to split that. I realize that the families, sometimes making them whole for their loss, you can't do that when a life is lost, right? Money doesn't fix everything. And in fact, it doesn't really fix anything when you're talking about that. But it is the only thing that is available to them at this point. So, yeah, that's going to have to wait till after the criminal case ends, and then it goes forward. All right, let's see. What else did we have happening today? Happening yesterday. It was a huge day yesterday. They also had the Karen Reed hearing, which was supposed to take all day long. And instead, what did it take? An hour? The judge is like, I've blocked off the calendar. You've got the entire day to talk about this case. And instead, we're going to give you each 10 minutes to talk, and then that's it. And wow. She ended up giving them a little more because they had all prepared, 90 plus minutes each. And but still, that was the Karen Reed case. The whole hearing that they were really, the main thing that they were meeting to discuss was whether or not this would be dismissed or not, whether the Karen Reed case would be dismissed. So we have a decision that we're waiting on, I believe, still from the judge. I didn't hear the very ending of that one. But the Karen Reed, the information that came out, just I think the defense is really trying to show that the information that was presented to the grand jury was faulty, was lacking. In some cases, I think they even say lies. So yes, very spicy, very, very crazy. Let's see. I did not watch Tucker's new hearing. I believe, what's the date on Tucker? Let me just make sure we've got him on the calendar, because that's coming up here April 4th. Is that right? April 4th is the Treehouse Murder Trial. We have a new judge, brand new judge, that doesn't have any of the history with Franklin Tucker. And I think that case is going to go very differently. Like, not just like the ending, but I believe that the rulings on some of the stuff in the case is going to go differently. I think different things will be allowed in that weren't before. So that's going to be very, very interesting to see that one. Wow is understating the shock. Yes, there were jaw-dropping moments in the Karen Reed things. Let's see, we've got Ivan's on the phone, alive and well.
Internal Revenue Service.
Hello, you've reached the voicemail for RA. This message is not checked. No. What's up, Ivan?
How's it going, guys? Long time no speak.
Are you still there? Are you still there?
Can you hear me?
Yeah, I just wiggled the cord and you go quiet. You said long time no speak. That's not our fault, though. We've been here speaking. Well, for the most part. I took Monday off, but.
Oh, okay. Well, we all need our days off, It's the little guy's 4th birthday today, but they're down in Florida on their annual Leaves Me Up to My Own Devices tour. So it's.
So the police are on standby, is what you're saying.
Sort of, yeah, sort of. I was just wondering, what do you think the Hannah verdict means for old Alec Baldwin? Like, do you think that lessens or greater the chances that his?
I don't think the verdict itself is nearly as concerning as the evidence and how they were going to prosecute. Because we're going to see, we literally saw a mirror image, just substitute the names. It's going to be very, very similar with Alec Baldwin, which I still want to watch because it's the shifting of the blame from the loading to the actual firing. So that part's a little different, and that will be spicy, especially when you've got video evidence that appears to contradict what he says what happened. I think him seeing that evidence in front of him, I think he's scared to death, and he should be. Do we
know if it's the same judge?
Same
Do we
judge.
know that yet or not?
Same judge.
Oh, okay.
So as far as like the rulings of what's allowed to come in, I think that the evidence will be mostly the same, and so we'll see a very similar prosecution style. Just instead of Hannah,
a lot of the same witnesses, right?
Alec. Yeah, we got a couple of them. Some of those expert witnesses are definitely coming in. Defense probably won't get. I don't know. They might not get the image enhancer guy. I don't know if they're going to bring him in or not. It's like, look, that didn't play well. That didn't play well with the jury. Okay, they really just look at us and said, "You spend our tax money on what?" So,
Can they call? Can they call Hannah?
can they call? They could, but she's going to plead the fifth because she's got pending appeals.
Okay. So when you can't knowingly call a witness that's going to plead the fifth, right? Like that's some kind of rule.
Yep. We'll hear from all the people who have deals though with the state. They'll all be there.
Yeah. All right. Well, right on. What's the next? What do you got next on the docket? I know I've been sort of in and out lately, and just wondering what's the next.
We've got a little one. We've got a little one with Judge Cedric in Washtenaw or wherever Washington. I forget what the name of his little town is. We've got one with him that is. It's going to be spicy. It's going to be probably this afternoon. I think it's slated for 3:00. We thought it was going to be first thing this morning, but it's going to be this afternoon. So we might have a little slow day until we lead up to that. We've covered obviously the two hearings that happened yesterday. We might cover Karen Reed again. I know a lot of people are covering it, but a lot of us in this community missed it because
she's got quite the fan club. Like she's got quite the fan. I saw her walking in. It looked like a UFC fighter walking in. Like she had signs and chants and flags and like.
I have never seen that type of support from for a non-celebrity in court. I've never
it was
seen
like
that.
John Dillinger was getting brought in. Like there were people like lined up, like they were ready to go for her. It was pretty intense. She's got quite the little fan base. That's good for her. We all need support. So,
yeah, it's
but
it's cool. I think the reason for that is because so many people are hearing what the defense is saying and is resonating, and they're saying, "Hey, this is wrong. This is an injustice." At least from what they hear, and I realize there's evidence on both sides of this, right? There's
well, it also doesn't hurt to be aesthetically appealing. Like that certainly is in her favor too.
I don't have that advantage. No, I don't think that's what it is. I don't think that people are watching her because she presents well on camera or looks good on camera or something like that. I really think that it's the message and the substance of the case that's really got people caught up in this and involved.
Well, yeah, because if you just look at the difference between her and that Corey lady out in Utah or whatever, like it's just
Corey
night
Richards.
and day, right? Like, yeah, she does not have the same fan club, I don't think.
She has a very small fan club, and she sends them letters about wagging the dog or something, walking the dog. I forget, but yeah, Corey Richards is going to be an interesting one as well. That's coming up. Corey Richards. Let me just check here. Let's do that homework today. Can somebody help me on Corey Richards? Do we have a new date set for?
All right. Well, now I give you something to do. As if you don't have enough. So
I've got 33 cases we're trying to follow right now that we're just.
Is that a baker's dozen, or what is that?
It's my baker's dozen. When I ask for a dozen donuts, I want 33. That's that's how it goes. I can't have a dozen donuts today. I ate half a gallon of ice cream yesterday, and not the whole thing. Not the whole thing. We bought it the day before. I showed that I had self control, and I didn't eat it till the following day. Okay, that proves that I'm not,
That's like squirreling away your stash and saying you didn't do it all. Like,
no, I split it with my kids and my wife. So I did. Right. I think I had the largest portion. I don't think it was half. But yeah. Anyway.
All right, man. Well,
it was good.
Good to talk to you.
Thank you. We'll see you, Ivan. All right.
Yeah. Bye.
All right. So I had queso for breakfast. So this is Tisha. Tisha, I think I saw you over on Melanie Little's channel yesterday. Was that you over there, or someone with the same name? I think it was you. Yes, I think we have time. I wasn't planning on doing this, but we have time to cover the Karen Reed hearing, and I'd like to do it. I'd like to do it mostly because our community, what we watched yesterday, missed the Karen Reed, and we're sort of hearing bits and pieces. Would you guys mind if we cover that again? A lot of people have heard it as well. I had Mountain Dew for breakfast this morning. I really did. But I've only had one, which is progress. I have 3 more iced in the fridge, just ready to go, but I have not done that. Let's do a catch up on the Karen Reed hearing, because I honestly, I really believe that this case is not going to go to trial. The farther we get along, I really believe this is not going to go to trial. Can we watch you cover Karen Reed and watch the rest? We can watch you cover and watch the rest. Okay. Yeah, I will tell you this. When the trial actually starts, I have told Brandy Churchwell I will not be covering this trial live. She's covering it live. I will not be doing that. That's out of respect for her. She is an amazing, amazing content creator. I love her. She does a great job. We share the same community, and I think if you want to watch it, I'd love it if you watch it over with her. That would be great. We'll have different trials. I promise. Sometimes we won't have the hottest, most glitzy trial, but I think that the community is better with lots of options. And when I say community, I'm talking about the true crime community. And there are some great people out there. And I don't think it's right for me to only let you hear me on the biggest, most popular trials. There are other people out there that do a better job with some of the facts and the data and stuff that's let out, that comes out in these cases. And Brandy's one of them. She is much better than I am at keeping track of all the little parts and pieces and little facts. And the Karen Reed trial, if it goes forward, is literally full of it, and she will do a better job than I will. So I have to bow out of that respectfully. But we can catch up on the hearing that happened yesterday if you'd like, as we wait for Judge Cedric Simpson's case to get going today. Let's see. Corey Richards' preliminary trial set for May 15th. Okay. Preliminary. So this is pre-trial, right? Or is that the actual trial date? Because if that's the trial date, I need to buy a ticket. May 15th, prelim. But no actual trial date, right? Or is that just... Let's see. I like the perspective. And honestly, so many great content creators that are actual lawyers who can give some insight and feedback that I'm not able to offer. Great people all around. I appreciate you guys, because a lot of times you guys learn something and bring it here and teach us, and that's great. Might also go back and rewatch the bathtub murder. That one's out of Idaho. I know it's day 7, but we could go back and watch that as well. Preliminary is not the trial date, but usually it's very close to. Like sometimes it's as close as a week to, and sometimes it's a month or two. But okay. Okay, that May is going to be interesting. All right, yeah, upper torso. The commands that put links, that spam links to the channel, we're just have the mods that can do that. So basically, they'll put them up as we talk about them, or as we sort of as they're requested if needed. We're trying to make chat more friendly and not go so fast. And so some of the things that make chat go fast is the auto response. Excuse me, I have the hiccups now. It's the Mountain Dew, the auto responses. So we're going to turn that down. Okay, so let me get Karen Reed's hearing lined up. I'm still keeping an eye on Judge Simpson. We're actually going to jump with Judge Simpson while I do the homework here, if that's all right. Give me just 1 second.
Aguilar.
Buenos días, la asistente del fiscal del
Spanish.
distrito, Lauren Perley, representando a la señora Hernández de Aguilar.
Please state your name.
Por favor, diga su...
She knew that part.
What's up? Marching Julissa Hernández de Aguilar.
Your Honor, today is set for sentencing.
Su señoría, el día de hoy estamos acá para la sentencia.
We have no changes to the pre-sentence report.
No tenemos ningún cambio al reporte de presentencia.
And ask that you adopt the recommendation.
Y le pedimos que adopte la recomendación.
Is there anything you'd like to tell me before I impose sentence?
¿Usted quiere decir algo antes de que yo le imponga sentencia?
No.
No.
To sentence of the court, you are placed on 4 months prosecutor deferred sentence.
Y le sentencio a 4 meses de lo que es sentencia divergente en la corte.
Are you guys learning
You had to pay
Spanish?
$425 fines and court costs.
Tiene que pagar $425 en lo que son las multas y costos de la corte.
Lois,
$120
thank you for the gifted
probation oversight
memberships.
fees.
Super generous.
$120 lo que son los cargos de la parte de probatoria o libertad condicional.
We might do the
When
bathtub
can you
trial.
pay that?
But we
¿Cuándo
want to,
puede pagar usted eso?
let's be on
La
this for a
mitad hoy.
second. Okay, so she gets 4 months. She has to pay 4 months suspended sentence and has to pay a fine. We have no idea what the crime is. We're looking at the bathtub trial. We might pick that up here in a little bit. I'm hoping Runkle's going to do nightly recaps of the Baldwin trial. I'm sure he will. He's involved in that one. It involves firearms. It's a high profile case. I'm sure Ian's going to be all over that one. He does a great job there. Okay, Karen Reed. Let's jump over to Karen Reed if you give me just a minute. Let's see. Let's back up here. Where's my mouse? It's hiding. Okay, let's jump over here. All right. Okay, Karen Reed. This case.
Judge, this is 22 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Hang on.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti for Karen Reed.
Good morning, Ms. Tianetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right, so
Okay, hang on.
when we were last here on February 26th,
Okay, so here's a catch up. Here's where we are. In this case, Karen Reed is accused of killing its boyfriend, right? Because they had a different name. This case looks like it's crazy. They went out drinking together. Then his body was found in the front yard of a cop buddy the next morning, frozen to death and with some injuries. And that was the yard where there was a party that was happening inside. The state came out and said basically she rammed him with the car and left him to die. And that is the further we get, it seems that the evidence maybe does not support that, and maybe in fact contradicts that. So it is boyfriend. So what we have here is, as the evidence comes out, Karen Reed, she has powerful attorneys. She has these are not your average public defender, and I'm not trying to belittle public defenders, but she has hired a full team, a huge team, to represent her. Normally, you don't get to choose a whole bunch of powerful attorneys to do this, but she's hired a huge team. They're doing a very good job defending her, and they're picking apart the state's evidence. They're requesting stuff. The state's not turning it over. The state looks very bad. And it looks like they're trying to hide something. And as they are getting information, especially as they have done this, they've released stuff publicly. It actually instigated a federal investigation, not of Karen Reed, but of the entire investigation, more of like the corruption behind it. And that federal investigation is finding problems. And those problems are causing the court down lower to rethink and change the way they're doing things. And it may actually end with her case being dismissed. I think it will. I think it's more likely that it's dismissed than not. This particular motion talks about is asking the court to dismiss her case. It's just for that reason, because of corruption, because of things that were not disclosed to the grand jury, because of things that the grand jury was misled. They believe intentionally. So all these facts are coming together, and it's starting to snowball and it's starting to build. And we have the tide turning, so to speak, on this on this case in favor of Karen Reed. So this motion, which was originally they were going to handle a bunch of different motions, and it was slated to last all day. Instead, it's going to be lasted a little over an hour, and then we get to hear all the juicy bits. Okay, we hear the juicy bits for why the defense says, look, this is why it's shady. This is why it's wrong. This is why there's a cover up. This is where we should be looking. This is who got a free pass. This is where the backroom handshake deals went down, and so we're watching all that, and some of this stuff gets come out in court. Now, I agree with Melanie Little. If you watched last night, as she did a breakdown on this, the judge seems to not want these details out, and so instead she's like, "Look, I read everything. Don't I don't want you to talk about it. Just know I read everything you sent me, and so you don't have to go over the stuff that you sent me. I read your filings." And she'll even interrupt and say, hey, okay, I know, it's okay. I know where you're going. I read where this is. She's trying to not have information released publicly, I think, which adds to the whole perception that there's some corruption here, that something's going on wrong, and so you'll hear this throughout the trial. It's the way the the defense presents this case. It's quite compelling. It's quite compelling. So we're going to go ahead and watch this hearing, and we'll stop just a couple times. There's a few points, but mostly we'll just let it roll. So let's get that going.
I first anticipated that today would be for all motions, but I did read the very detailed affidavit from defense counsel regarding dates and what we should cover. And so today, as you know, I changed some of the dates to accommodate you. I think there was some short trial dates you may have had, or restitution dates, and so you did get the order on the new dates. So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions. So I don't remember if it was Mr. Jackson or Mr. Yannetti who last time said that I was operating from a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office. So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began. I've also read the pleadings.
I see clearly now
the motion
rain
to
is gone.
dismiss. Defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also, I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings."
Okay, so here she's like,
I've read everything.
Does that make sense?
I'm going to
Does that make
give
sense?
each side.
I'm going to try to get rid of that mouse cursor, or we're going to find a different feed that doesn't have that. She says, the Fed say we hope the parties will only disclose the parts they need to in court. Okay, there are some juicy tidbits in this filing, very, very juicy. I'm sorry, I'm trying to get the feed up to where we were here. Let's see, is this it?
10 minutes, and we're going to start with.
We're going to start.
Defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also, I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So, go ahead.
High bar. Love that soft R.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah, all day. But that was when we had all the motions, but it's just these two motions
right,
today.
But they're big.
They're big.
Consistent with.
Why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that.
Right ahead.
I'll start with the basic rule of Odell.
Look how full the court
we start
is.
with the postulate that any distortion of the evidence, that's where we start, any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I will, again, I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say,
She's like,
your
I know
memo
the details.
is very thorough and very helpful to me because you outline everything and same in your supplement.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship, and I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He had been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was, quote unquote, deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam, all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E attached to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant
These
Lank is a
allegations are
longtime
crazy.
childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages but from the feds revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So, yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words. Because we didn't create anything. And there's more.
Oh, there's more. I love that.
On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift. Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm gonna go write a report, I'm gonna turn it over to Mr. Lally, and Mr. Lally's gonna turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife, it'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages.
Whoa.
2 years later, to the day, on February 1st, 2024, now let's fast forward 2 years later, now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA under very intense questioning
States Attorney
that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Buchnick, all of this before Yuri Buchnick testified at the grand jury and before he and Buchnick actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Buchnick testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Buchnick knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Buchnick, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could implore the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read.
We don't want those details.
So I'll give you 5 more minutes. Go
Thank
ahead.
you.
Public.
I want to shift gears to another example, or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert, when that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case. And that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault, certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion in front of the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust. The ones that are supposed to protect our interests, and the law does not allow this sort of conduct to go unchecked. When the remedy when this sort of travesty of justice occurs is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance, I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you.
10 minutes is up.
Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
Sure. He's saved. He hasn't used all his ammunition. He has more, and he'll get it.
Thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can. Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation on the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met their burden with reference to any of those three elements. Just addressing sort of the overarching themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card monte trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcript, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe. But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these materials are materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last date, that these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians' witnesses' testimony that we've received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight, there was no dog attack, there was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for 2 no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided childcare in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened.
It never happened.
Lastly,
we have a text message from the FBI extraction.
The Google search.
It never happened.
I would agree with counsel in the sense that it's really no longer open for debate. But I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially, what we have is, yes, what counsel mentions is there is one expert who was given 2 extractions, presumably provided by defense counsel, that indicate from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of those, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that. But based on the totality of the evidence and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
Oh, yes.
First of all, it's always interesting to hear an argument that suggests there's nothing to see here. And that's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. It's the fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. It doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period, full stop. That's their independent expert, not ours, not somebody on our payroll like Mr. Whiffen, or one of their experts, or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness, or series of witnesses, who say unequivocally, that car did not hit John O'Keefe, and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these two texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were, in fact, in communication with each other as early as 2020.
When's the last time you sent a no-content text?
And with regard to the 2:27 a.m. search, it's not a three-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember. What they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well.
Boom.
All three of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it and deny this motion. We're talking about the integrity of what is the foundation of Massachusetts' judicial system. And that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right, thank you very much. Mr. Yannetti, are you all set?
Yes, Your Honor, thank you.
Next.
So the same time, and let's see how you do with it.
This is the new motion, right?
We believe our witnesses. They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt.
He's reading quotes.
Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome.
Want to kick the prosecutor
Your Honor,
off the
this court
case.
should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal, as a result of his egregious...
Can I just interrupt there and ask you, are these going to be the same motion, essentially?
Oh, no, it's all new.
There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr. Benetti.
No, it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of it is different.
Understood.
All right. So I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt End quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never, in over 30 years of practice, have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence, and I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So, for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. What? We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation That is outrageous.
That is
We are
outrageous.
outraged that he lied to us.
We are
This
outraged.
court should be outraged that D.A. Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that D.A. Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you.
Judge, I'm going to need about
Indeed, Your
3
Honor,
more
Justice
minutes.
Jackson practically spoke to D.A. Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, D.A. Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done.
The feds aren't done.
D.A. Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, D.A. Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, I'm sorry, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, My client deserves a neutral, impartial prosecutor interested solely in justice, with no vested outcome in this case, and it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case, and that is why I urge you to do just that in the interests of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally?
Karen is
All
clapping.
right, so let's start with 10 if you need more.
All right. Next. How do you respond to that?
Thank you, Your Honor. And again, I don't think I'm going to need much more than that.
State defense beat you up and stole your lunch.
Again, I know the court has reviewed all the materials, and I know the court is well aware of their standard, and it's a standard which I would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers.
This happened.
That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rules of Professional Conduct 3.6c. Which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So, yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably crossed the line of permissibility under Rule 3.6, and that meaning defense counsel. That the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case, and that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time. Denying it without prejudice. And then Mr. Giannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Giannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house, I think he was confronted, was likely brought down to the basement. I think the confrontation got physical and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on and continued that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant, traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go, as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on a subsequent indictment. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth, nothing was asked for from the district attorney's office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous. Disingenuous would be about the nicest term that I can come up with for that. Thank you.
All right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
As long as it's short, whatever
I
it
would
is.
just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your motion?
I believe they're outlined. Yeah, they're outlined, Judge.
Okay, I ask because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, because with Rule 17, as you know, the record holders come into court and object. So I don't want you all to be on the screen. And Ms. Giannetti, certainly your local counsel. Mr. Jackson, if you want to be on the screen, you can. But I need somebody here.
I understood, Your Honor. That's fine.
Okay?
That's fine.
It makes sense to me.
Yeah. If I may just...
Yes.
Karen Reed, March
Can I
20th.
appear in person and have my client join me?
No, she has to be here.
Okay. Thank you, Judge.
All right. Was there something else? Yes.
I would ask, may we approach just as the scheduling issues?
Okay.
We're going to approach some scheduling issues. Lots of people in court. Lots of supporters. Lots of family, lots of friends. Lots of public interest. I think Turtle Boy said he had a hearing tomorrow in this one, right? May end up going back to jail because he did 60 days already, right? Valerie, this case is the Karen Reed case. Brandy is covering this. So this happened yesterday. She covered this hearing yesterday, I believe, as well. I think. We're just taking inventory of everybody who's here. Initially, Jennifer, there was a huge show of support by law enforcement for the prosecution, for the Commonwealth. I'm not seeing that now in this hearing. And maybe it's the nature of the hearing, but this is the court beeping to let us know that the white noise machine is on. I believe there we have Karen Reed's, or excuse me, we have JJ's family on that front row. The police presence has fizzled out. What you're seeing now are bailiffs. Those are not officers there to show support from one side or the other. Those are the bailiffs that are there strictly to maintain order in the courtroom. Yeah, this is different. These are bailiffs, and the bailiff presence is directly related to the number of people who are interested in the court case, and the allegations of the court case. The more violent, the more salacious. The worse the information is in court, and the more people that are interested in it, the more bailiffs you're going to see in the courtroom. They're there just strictly to keep the peace and make sure that the court can proceed in an orderly manner. I do think it's important for justice to be done. I think it's important for justice to be done. I think that Karen Reed's defense spins a very compelling story, and it is their version of the events. It's their view of the events. They're very good at what they do. I don't know if what they're saying is all the facts. It's the complete picture. Put me back in the hospital. Beep, beep. Feel like I'm in the ER. Salacious is a good word. It is. The beeping is the white noise machine to let us know that it's beeping. Apparently it beeps because it can. I can turn it off if you don't want the noise. We'll turn off the noise for a little bit. The end court's over for the day. I think it is over. So are we on life support? I think we are. Okay, so So court's going to end like that. I'm going to skip forward just a little bit and make sure there's not another little bit at the end. There is a little bit at the end. Hang on. Skipping.
All right, you had a question, Mr. Jackson?
I did, Your Honor, just about the logistics of the trial, meaning days in trial, half days, 5 days a week, 4 days a week. I wanted to get some sort of sense so we can begin planning.
Okay, so we're going to go full days, Monday, Wednesday, Friday, half days, Tuesday, Thursday.
What?
Are the half days afternoon or half days morning?
Mornings.
Okay.
Okay, anything else right now?
Can I have 1 moment?
That's a weird little schedule. I wonder why.
No, Your Honor, thank you.
All right, anything from the Commonwealth?
No, Your Honor.
Mr. McDermott?
Judge, I just wanted to put on the record
Okay, so
that
they're
I
done.
think I provided to everyone copies of that letter from Google. I just wanted to make sure, just put that on the record that I gave you copies of that. Thank you.
Letters from
We
Google.
received copies.
All right, great. All right, thank you very much.
Thank you, Your Honor.
All right. So as they're done, we now I'm trying to get back to Judge Simpson's court very quickly because I think. Oh, actually, we've got some time. For some reason, I thought it was 12. Okay. All right. Judge Simpson is still out and about doing his thing. What is it showing, actually? Hang on. What is that on the bottom? Wrong answers only. What is in the bottom? Ronald Moody, what are you showing? Oh, we're looking up at the ceiling, and I think that's a drink can. It's a ceiling fan on a popcorn ceiling. Jolt? Lilt? What's the drink?
And monitor compliance of recommended treatment. It is therefore the sentence of the court. You are placed on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you get that paid, sir?
A week?
To pay it all?
Yes, sir.
March 22nd, 2024. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You continue weekly random testing at community corrections. I don't want any further positive tests. You understand that?
Yes, sir.
So all of that information needs to be provided to them regarding his prescription medications.
There's a silver
You are to
primary.
complete an IOP program, including all recommended aftercare with status reports to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of prescribed medication to probation within 7 days. You're to provide proof of victims impact panel attendance to probation. I will order 93 days jail. Credit 1. The balance is suspended.
It would be funny if the guy was on probation and he's like checking in or something on Zoom, and it were a beer can or something.
Yes.
In the picture.
Cancel the bench warrant.
Cancel the bench warrant. That's no fun. Okay, before we get too far,
Cause case.
before we get too far in that, let's just go back and talk about what just happened. Man, we've covered a lot of different stuff this morning. We've been jumping all over the place trying to do what I called a courtroom roundup today. We've got 3 different cases we've heard updates on. Some civil, some criminal. And now we're getting set. I think we can probably wait. I did promise to answer the phone. Hang on.
Call from Angela. To accept, press 1. To send.
Angela.
Yeah.
I told you should call
Hello.
afterwards. Welcome. What's on your mind regarding the Karen Reed case?
Well, I have to say something. I have followed Karen Reed's case since the beginning. Like, I don't know, because one of the first true crime channels covered Karen's case weeks after. And it is mind blowing what you saw today on the hearing. It's just a small piece.
It's teeny
of what happened and what Commonwealth did not disclose.
There's
Tiny,
issues.
little,
There's
yeah.
issues with video cameras
Yeah.
and portions of the video being cut out. There's all sorts of issues with the snow and
Yeah.
the light and the pieces and the dog. Oh my goodness! The who suddenly gets rid of their dog, changes their carpet, sells their house, does all this. Quits the school football program. Moves for no reason suddenly. There's just all sorts of situations in this case that just make your mind go, what just happened? What's your reasoning for that? Crazy.
Wait, you haven't. Hold on a second. They did not cover this, but there is something else.
Well, there's lots.
There is this. There is this about taillight. And apparently she backed into so the taillight was whole around when she left the bar with John, and it was whole afterwards. And around 5-ish a.m., when she left the house to look for John, she backed into John's car. And that's when she cracked the taillight. She not broke the taillight, she cracked the taillight. And then, there is clear pictures of it that, you see clear headlights on the surveillance cameras, independent surveillance camera that does not belong to anyone involved in a case, and you see a clear red taillight, no cracks, nothing missing, when you break the taillight, and you see white light, if there's a piece missing, you see a red light, which means it's not broken, And all of a sudden, she drives to Jen McCabe, then to where John's body was found. And even Jen said that she saw that her taillight looked like it was cracked. She did not say initially that it was broken. She said it was cracked, And that was her first statement. And then and how they got a hold of Karen's blood sample. That's a whole other story. How they manufactured she is I'm not going to say the word, but you know what I mean.
Mm-hmm.
So that she has to go to the hospital to be checked out, and they draw the blood, and then they calculated, and that's a questionable how they did it, that she was way over the limit at the time around 1 a.m. when she allegedly killed John. And that's the range they said that her blood alcohol test it's way too wide. I know the equation. It does not go that wide. It's very, the range is very tight. They were between 0.08, so just at the limit, and 0.16, I think, or something like that. Double the,
that's a wide limit.
Yeah, that's a really wide limit.
Somewhere in that range is what she had. Yeah.
Somewhere in that, yeah. I was that's impossible. I know I looked up the equation. That's impossible. When you look at the equation, you get a really tight limit range. Not that wide.
Yeah.
And that's just a few things. But what really gets me is that the said taillight. They said because she hit him. When she hit him, she broke the taillight. They found the piece of taillight in the snow several hours later. They did not secure the scene.
Right.
There are also what happened is that they went because her car was at her parents' house, which was 33 miles away. So she went from the house where the body was found to her parents' house, And then it was towed back to the Canton Police, not the Massachusetts State Police. It was towed back to Canton's Police Department, and it miraculously, it was about 66 miles plus minus a mile.
Yep.
It miraculously pieces of taillight was found on the car. I don't know exactly where, but it was found on the car.
Yeah.
Like, in the snow, towed. They found pieces of taillight. It's like, it's impossible. Did they use was it glued or what? And they found allegedly pieces of taillight on John O'Keefe's shirt, which is insane. Seriously. It's like, what?
This is
and
so
other
bizarre.
things. This is so bizarre. And then his arm. Seriously, like, it's clear that, people that have worked with canines their whole careers, we are talking canine handlers, say, without knowing what's the case about, without knowing where the picture came from, they were like, oh, this is clearly a bite from a dog, a German Shepherd, without even thinking. It's like, it's insane. It's insane.
Okay, Angela, let me tell you this. I love this. I'd love to have this information. I have a source that I'd really like to send people to because we've just whet a lot of people's appetites when it comes to this trial. And some of you have followed this all along, and it's going to be great. It's going to be amazing. Brandy is covering this trial. Not only is she covering it, she has a podcast that she put on, podcast just about this trial. It's called Conspiracy in Canton. I'm going to put a link to it right now in chat. If you give me just a minute. Just 1 second. There it is. So right here, there's a link that will take you to the podcast page of Brandy Churchwell's channel, and you'll see a link to, what is this with promoting other channels? Kurt, welcome. Oh my goodness.
Yeah.
I'm just saying that the people who are trying to get caught up on this case, Brandy Churchwell has done a deep dive podcast on it. I think she's got 8 episodes into this. There may be more coming.
Yeah, I just opened it.
If you need something to keep you awake at night, which we all have plenty to keep us awake, but if there's some downtime you want to catch up on this case, it's amazing. I think the Karen Reed trial, there are many people. Send them to Uncivil Law. That's great. Uncivil Law will give you the legal side. Brandy is a charts and data side. She crunches the data.
She's my kind of person.
Yeah, we love Kurt as well. He's also got all sorts of coverage on this as well. Thank you very much, Kurt. Good to have you in here as well. Anyway, if you want to catch up, I won't go any further into it because honestly, it takes a lot. There's so much to this case. There's so much information. There's so much that's happened. There's so many different statements that have been made that need to be compared with each other and time-stamped and cross-checked. This is right down the alley of somebody who's dedicated to doing just that. And we know what Brandy did on the Murdaugh trial. She's doing this on the Canton case as well with Karen Reed. So if you want that catch-up, I would say definitely check that out. Give it a listen to the podcast. I think that podcast itself is doing phenomenally well just on the stats. Let's see, 8 episodes.
Yeah.
Yeah. Anyway, Angela, thank you so much.
Yes. I just wanted to, on the other note, I wanted to call in yesterday. You made a joke about people flying away or jumping the bail. I have a funny story that I wanted to tell regarding that. A neighbor of mine in Serbia, she moved to Serbia from Germany, and he was all right, nothing suspicious happening. And then, like, a few months later, we found out that there was a yellow wanted notice on him, and Interpol came and arrested him.
Busted.
Yeah. So, yeah. Oh, and another note, the other day you said about, there was someone from Australia about you traveling to Australia. There is, that saying that money does not grow on trees. Mm-hmm. Well, there is, that does not really, it's not completely true.
They have money trees in Australia?
Because Yes and no, because because there is eucalyptus. Eucalyptus tree has really deep roots. So if you find an eucalyptus tree, you might see gold gold on the trees, which means there under that tree is or plant is you can find gold. So yeah,
I know that the huge gold nuggets grow in the ground in Australia. They found like a 44-pound gold nugget, and for me that's enough. I'm not picky, but 44 pounds that's enough for me. I would be done. I'd be like, okay, I'm good. I've got what I need. You guys can have the rest at that point. That's a lot of gold, but yeah, Mega Millions did not come in, so the money tree lied to me. Man, what was it? 785 million or something? 45 pounds. I'm a little more conservative. 44 is enough for me, Kurt. Angela, thank you for the call. Thanks for the updates. I appreciate it. It's always wonderful to talk to you, and thanks for being patient to call in too.
Thank you so much. Goodbye.
All right,
Have a nice day.
We'll see you. You too. Bye.
Also, one thing. Hold on a second.
Okay.
I have the letters that AUSA sent to the Morsi. Do you want it or hello?
Hello.
Yeah, I have the letters that U.S. Attorney sent to Morsi, the DA. I can email them to you if you want.
That would be great. That would be great. Yeah, send them to my email.
Yes.
That would be. Thank you. Thank you very much, Angela.
Yes. Yeah.
I appreciate it.
Bye.
All right. Bye.
Bye.
All right. Love checking in with our friends across the pond. Let's see. 44 pounds times 16 ounces is 704 ounces. Hey Siri, what's today's spot price for gold?
The ticker says gold is up right now to $2,178.20. That's $12.10 higher, or 0.56%.
It's only 1.5 million, 44 pounds. 1.5 million. That's conservative. That's conservative. My monitor. What about my monitor? What did I say about monitor? Chump change. Yeah, seriously. I mean, who doesn't have that just laying around? I mean, maybe not in these pants, but in the other ones. Yes, everyone's Siri just responded, which is great. I love it. Hopefully you all woke up at 8:15 this morning as well when I set your alarms. You can't travel out of Australia with anything at all, so there's that. I could probably convert it. All right, let's see. Here's what we have. We've got it's lunchtime here now. We have a 3:00 appointment with Judge Cedric Simpson for a very spicy trial, and when that starts, I think it starts at 3 Eastern time. Taylor says Brian Koberger of Idaho Supreme Court denies appeal. He's appealed everything. He wants everything thrown out, the case dismissed, everything. It's like everything that Karen Reed is doing in her trial, Brian Koberger is doing in his, but Brian Koberger has actually zero chance. He's citing law, or at least law philosophy. What do you call this? From like the 1800s. Yeah. What is your top monitor? What does your top monitor show numbers? Which one are you talking about? Like this one? This monitor? Because he cited the Magna Carta. You'll have to call in the burner phone and ask me the question about the top monitor. I don't understand what the question is. Uncivil Laws making lunch for everybody. Just thought I'd go ahead and throw that out there. Thank you, Kurt, for that. Taking orders. I honestly, I'm standing by this. I don't think Karen Reed's going to go to trial. I think the feds are going to put a stop to this. It's going to be done. Internet speeds. Okay, internet speeds are right over here, right there. 6.24 megabytes per second is my internet speed as far as the upload, because I'm putting out 1080p. Next to this is when I'm recording. It tells me how much space I have recording. I don't have a drive connected right now, so there's no recording. Top monitor shows camera levels on. Okay, I'll explain. You know what I'll do? I might be able to put this screen. Okay, here's what I have. This big picture right here. That is my multi-viewer. So everything that goes through here is, most of it is shown up here. So the big picture on the left, that is what you guys are seeing right there. Right here, this is camera 1. Looks like that, which is blurry, by the way. I just noticed. Sorry about that. There we go. Now I'm in focus. That's camera 1. Next to that, we have, this is my Apple TV. We're watching Judge Cedric Simpson right there. This is an alternate monitor for my laptop. This is camera 3. So that's where we just watched the Karen Reed hearing. GoPro is camera 4 right there. This is preview. So when I hit cut or take, basically this is what's lined up. So I can line up next. I want to go to here, or I want to go to here, or here, or here, or here's this. We're going to end. So I put the logo. That's what's going to come next. These are my audio levels. I can watch all my channels and make sure the audio levels are right. We use my Fairlight mixer, what's turned on, what is off, where the filters are, the high pass, low pass filters, as well as equalization, compression, and all that. Let's see. Next to this is camera 7, which is a spare monitor for this computer back over here. Camera 8 is the computer that is right down there. That's the Mac Studio, and that camera 8 is running this right here. So that's why it shows up camera 8's right there. And behind, you can't see right here, this is called Super Source behind this monitor. And that's a virtual screen where I can mix and match several different pictures. Like, let's see, let's cut to Super Source. I'll show you. It looks like this right now, but I can, using my desktop, I can move pictures around.
I'm learning the self-discipline to sort.
I'm going to turn off the audio. I can move pictures around like all different ways. I can just set up the cameras anywhere I want with any number of pictures, or just anything you can possibly imagine. I can make happen with this system, and this is why I bought the switcher actually. So, I mean, you can dream it up. It's probably got a preset. If it doesn't have a preset for that, it at least can I can manually plug it in. So that's this machine right here, and it's worth every penny of $1,300. I love it. Next to that is what's called a media player, and that just shows still images. So this also has up to 20 still images that are stored, and it shows me what is queued up in one of the slots. And then we have the recording and the live stream. Is that what it was? Did that answer your question? And if you are doing any of this and you want to know how to make this work, if you want to completely over-engineer your foray into YouTube, I can help you with that. Can I do a star wipe? Oh, let's see. Star wipes would be like, well, that's a wrong one. Let's see. I can do all sorts of nifty. Why is this one not working? Not that one. Let's see. I can squish things over different. Yeah, I think I can do a. Let me do a quick setup. I can play with it. I can actually make the transition. See how that, like, the blue bar goes across the screen when I do this. I can make that transition be a picture, so it like scrolls past my logo and stuff like that. I'll work on the star wipe. I think it's in here somewhere. Let's see. Transitions. I've never been big on transitions. I mean, star wipe is all about Homer Simpson. I get the reference. Let's see. How much for your exact setup? For Millionaire? That's where I'm at. And this is over years and years of building it and putting it together. But, here's Mrs. RA. I have to hide the number. But they're asking how much I spent on equipment. Yes, it's a lot. But it allows me to do things I do not use StreamYard. I only use StreamYard for a podcast. StreamYard actually replaces this this piece of hardware. It replaces this hardware with software, and it's powerful. It does great things really well. It's easier to bring guests in with StreamYard than it is through this piece of equipment. But StreamYard can crash, and it's dependent on your processor on the computer, and it can get laggy. Whereas this piece of equipment is dedicated, and I can literally just start shutting off devices, and it won't affect my stream at all. So my head is being cut off. It's getting bigger. We're talking about technology. The hardware seems much cooler. I like it. What's wrong? It's all right. It's all right. I'll fix it. A swoop is more complicated. I'm working on getting a swoop that will actually play from this hyperdeck over here, which is powered off. Miss Sorry, do you need me? Okay. Anyway, I'm happy to share. I do this. I have helped a lot of people who are starting YouTube channels. This is not the right setup for most people. I'll tell you, this is over-engineered. Oh, ouch! I just broke something. Let's put this over here. Over here. This is part of my favorite stuff. This is absolutely this is so cool. Anything that happens on my stream, absolutely anything that happens with the video, from turning audio on and off on, let's see, who has audio. Input 2 is going, right? I can turn it off and on here.
I understand the work.
From Judge Cedric. I can change anything about the pictures. I can switch to to the super source and back again. I can do all that all using these buttons. And I think it's like 170 different pages. So like by pushing different buttons, you can get to different points where there's 170 different setups. And that software costs a little bit as well. And it has to run on 2 computers. There are 2 computers powering it, and then also this. So it ties in a lot of things. But this is not the right setup for most people. It's just right for me and what I want to do. All right. What I was saying though, before we went on this rant, shake it, don't break it. Yes. Elgato Stream Deck. I like Elgato. Yes, it is a Stream Deck. It's the biggest one, the Stream Deck XL. And then I'm running Mix Effect, which is Adam Tao. I don't know how he pronounces his last name. It's a program Adam Tao made specifically for programming Blackmagic Design ATEM switchers. Power company is thinking, I think I'm growing pot. Yeah, they probably will. Oh yeah, you're getting a tour of the buttons. I'm not going to show you anymore. We're done. Have you counted all the buttons? The button challenge is still coming. I have to work on that. All right. Anyway, we have a working verdict clock. We do, thanks to Google. Thank you, Google, for a working clock, a stopwatch. I missed your milestone message. Let me go back and see if I can find it. There it is. Bite Me says, such a nerd. 14 months of your nerdiness. LOL. Thank you, Rebecca. Appreciate that. All right, we're going to go to lunch. When we come back, we're going to come back with Judge Cedric with his spicy court. So we're going to take about an hour and a half. Does that work? 1:30. We're going to come back at 1:30. How do you get callers to broadcast over your system? Great question, Jermaine. I use a soundboard right here. So let me show you. The soundboard, this is actually the old Rodecaster Pro. There's now a Rodecaster Pro 2, which does almost the exact same thing, and it just looks a little cooler, like it has more lights on the knobs. And it's a little easier to switch between sound bites. But the inputs on the back, it has 4 XLR inputs, which are these microphones, right? So like this microphone right here, when there's a cable in it normally, if I can show you, it has one of these plugs, and the XLR cord would plug into the back over here, which is what my mic has as well. It goes in around the back. So it has 4 XLR inputs, so I can have 4 microphones. Next to that, it has an input for a phone, it looks like a headphone jack, but it's a tip ring sleeve, which means it has 2 black lines instead of just 1. And that allows you to have microphone and audio carried on the same cable. And so I plug that in right here, this cable. It goes around and it plugs in through a little adapter to my phone. The phone has one of these plugs, right? Because I have the old iPhone. It's not a USB-C. And I have a splitter so that one can be power and one can be audio. So I can always keep the battery powered. And then you also need another little adapter so that you can plug in your connector into the little lightning adapter. So I have that, and that plugs into my phone. So that brings the audio in as one of the channels. Like this channel right here is the phone. So I can turn the phone volume up and down, and that allows you to hear me. And then the audio from this system comes out of one of the 4 headphone jacks and goes back into my ATEM. So it's fed back in as an audio feed. So some audio comes straight through here from HDMI signals, like all my different views, and my audio and the phone audio and some of the sound effects. If I play them from here, come from that. If you were playing a sound effect, it comes across from this computer into here and then back, because camera 2 is the sound effects come through on this channel. So if this is down, your sound effects aren't going to work. If it's up, they're going to be full volume. Never done a back tour like that before, but is there? Yes, I do have links to some of the equipment. If you're honestly interested in getting some and you have questions, obviously I can't answer like a million questions, but if you've got some, a little bit of help you need, I can direct you one way or another. I've tried a lot of the equipment that's available out there. So, all right. What is Judge Cedric's command? I don't think we have a command for him. We just have him professing his hatred of...
Thanks. I don't want pickles either.
He doesn't like pickles. We should do an RA Amazon page. I think I can do that, Judy. I just don't know how to build one. I am officially I'm pulled up on Amazon, so I could do an RA Amazon page. That's like where I tell you things that I like or I use. Is that what you're asking for? Just ask him one question, and he'll answer a million. You ask me a question about tech, and I will just not stop talking. KH in South Carolina, best 14 months ever. Thank you very much. We appreciate that. Let's see. We're Karen. We did catch up on 3 hearings yesterday because yesterday was huge. I am an Amazon affiliate. I think I'm an influencer. Which is what you need to have your page. I just don't know how to set it up. Grip Bottoms, you might have to call me and help me through that one. I don't know exactly what the benefit of that is. Do you owe us the story of why you were pistol whipped? Did I miss? Yes, I did, Mickey. Okay, we'll do a quick story and then we're going to go to lunch, okay? All right. High school. I think it was my junior year in high school. Imagine me being the star basketball player. Well, that's completely the wrong image. I was not the star basketball player, but I was one of their biggest fans. And my basketball team, I say my because it was my high school, I had zero to do with the basketball team's success other than I cheered for them loudly. But I did attend the basketball games, and guess what? Our school was the best in the state. I say that because we won the championship in the state. So I can claim that. So my school was the very best, at least that year. And the state championships were held in a big city, not far from us. They were late at night at a college. And so a couple, my buddy and I were like, hey, let's go to the game. And we drove, and of course we're too cheap to pay for parking. So we park in some, way far away. We park far away, and then we have to walk after the game, and we completely trounced the opposing team. I say we because the basketball team, and I have ownership in this. So we trounced the other team, and as we're leaving with all of our yay, go school, our team is the best colors on, and walking down these dark streets of the city back towards where we had parked, a couple members of the opposing team's fan club came by and were yelling at us. They were not happy having been beaten because I think they were also like unbeaten up to that point. So they thought they were going to go get in be the champions, and it turns out that we were. And so here we are, just two of us, and there were like 4 of them in the car, and we're approaching an intersection, and I'm like, just ignore them, just keep walking. There's more of them than less of us. And as we got to the intersection, they were coming along on our left, and we were going to turn right. And I'm like, I'm not going to go out. They're going to hit me. Well, my buddy who may or may not be in chat, was walking, and I stopped, and so the car went in between us, and now we're separated a little bit, okay? And so I'm like, they pull forward a little bit. Passenger jumps out and comes run up to me, and he's holding a revolver, and he's holding it backwards, so he's holding the cylinder and the barrel. And I'm like, oh, you know, where do I run? I sort of froze, which was bad. And then he was holding it in his right hand. He comes up and he swung it and he clocked me right in the side of the head with the butt of the gun. And I like spun around. I think I made contact with him of some kind. I like in my head, as I tell the story again, I like to think that I like knocked him out with a spinning reflex blow. Probably didn't happen. But I did spin in a full circle and then ran away. And my friend and I think both cleared a very tall fence. But I don't remember clearing it. I remember looking back and seeing the fence was now between me and the person who had the firearm. And we ended up running to a gas station and calling the police. And they're like, what, you know, you're not shot? So what's the problem? No harm, no foul. But yeah, they never got him, and I mean I got pistol whipped, but that's it. So I know what it feels like. It's not cool, not cool. I'm a gangsta. Anyway, that's it. That was high school, all over a basketball. We said nothing. We didn't flip the bird. We didn't do anything other than just like represent our school and be walking home after we beat them. So, yeah. Anyway, that's it. On that note, it's time for lunch, and we're going to take a lunch. We'll be back at 1:30, which is about an hour and 15 minutes, a little more over an hour and 15 minutes. I'm just looking. Yep, in chat, my friend is not here. He might tell the story a little differently. One day he might call in. He did not get pistol whipped though, so I figure I have the right to the facts because I got the brunt of that one, literally. All right, you guys, thank you very much for being with us this morning. This is the best place to watch true crime because of you, because of this wonderful community, and thank you for that. I've got street cred now, yes. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be in about an hour and 15 minutes. We're meeting this afternoon for Judge Cedric Simpson. He has a spicy trial. My son is dancing next to me, so everything's shaking. He has a spicy trial we're going to be for. It's the, what's the name of it? Hang on one second. It is, wait for it. Still waiting. John Torres. That's what we're going to have after lunch. I think it starts at 3, so we'll have maybe a little bit of court hopping, and then we'll be back. So take your time, have a good lunch. We will open up the chat if you want to be first in chat. You could win the internet. It could be you. It'll happen here in just a minute. So be ready with that refresh button and just make sure you're quick on typing whatever it is you want to type in chat. So we'll give that away again. Thank you all. We'll see you after lunch. Be good to each other. Bye-bye.